Good morning, students. Welcome back after a short break. Okay, students, as I already shared you detail about the promisors and the promisee, both are in individual and a jointly manner. As we already discussed, whatsoever the responsibility pertains to the promisor, whatsoever the responsibility pertains to the promisee, what are the mediators in case of any death of the person, whether it is a legal representative or a third person or an agent or etc. All type of all things. In case of any person absence, any person is going to be a part of this contract to make it accomplish of the this any kind of agreement. Now the question arises, what happen whether any person is not able to complete or fulfill their contract. Now to complete this fulfillment, law gives a remedies. In legal manner we have some sort of remedies. Now we are going to discuss all such remedies which are totally legal, and law gives a protection and helps you out in case of any person is going to be disown the contract. So let's first read the remedy definitions. It says when a party breach a contract by refusing to perform his promises, the breach of contract take place. Okay. Now, what type of remedies do we have? We have a 5 type of remedies. Number one is a suit for rescission, then a damages and a quantum merit, and for specific performance, and the last one is suit for an injunction. Let's read the first suit for recession. Section 75 of contract at 1872 says it a right to cancel the contract and not to perform obligation when one of the parties to be contract breaches the contract. If the aggrieved party wants to sue the guilty party for damages for breach of a contract, he must be sued for rescission of the contract. When a court grants rescission, the aggrieved party is free from his obligations and become entitled to compensate Section 75. Here we need to understand few things which may be a difficult or a new words from you. Let's take the words one by one. Number one is obligations, which I already told you. Obligation means duties between both of them. Aggrieved for a party means a person who is suffer from any kind of losses or any kind of imperformance of the contract. That is called the aggrieved party. And number three is the sue. Sue means a case. Guilty party means a person who needs to be paid the amount or who needs to be compensate in any manner. That's called the guilty party. It's the opposite of the aggrieved party and guilty party. And the last is the damages of breach. What are the damages in case any person cannot fulfill the contract? What are the damages or what type of loss does he has to be bear in case of non-performance of the contract? So this section 75 simply says whosoever can unable to perform the obligations of the any kind of contract, the aggrieved parties may file the suit before the honorable and competent court for grant of recession against the guilty party to become entitled of the compensation. So by which he can get the compensation whatsoever he is going to be suffer from loss. If in case there is no loss, as I already told you, there is no case for this in this regard. Let's take the example for section 75 under suit for recession is a Carol pledges ornaments to David and gets a loan. Carol does not return the loan to David. David may resign the contract and refuse to return the ornaments on a payment. If I can take this example in a very polite and a simple manner, Carol pledged the ornament to David. Let's replace these words with the Carol and a person who is going to pledge his precious instrument, that is David. It can be replaced with the word bank. Whenever you are going to borrow some sort of money from the bank is going to pledge or mortgage something in returns. In case of non-payment of any kind of loan, then the bank is going to be uh, hold your precious item or a valuable thing until if you pay the amount of your valuable thing, the bank is bound to repay the whole thing which you pledge or mortgage in regard of that thing. So Let's move to number two. That's a suit for damages. Damages section 73 of again Contract Act. It's based on the five thing. Number one is ordinary damages. Number two is special damages. Number three is exemplary damages. Number four is liquidated damages, and number five is the nominal damages. Now let's read one by one what these damages says in their manner. Number one is ordinary damages. Ordinary damages again it pertains to the aggrieved parties who can claim damages for loss which is the direct result of a such breach. In a contract of a sale of a goods, the damages payable are the difference between the contract price and the market price at the date of breach. The consequences, increase or decrease in the market, will not be considered. It is laid down in section 73. Let's take the example of the ordinary damages. Mr. Anil contract to pay 1 lakh rupees to Mr. Basit on a so and so date. Anil does not pay on that day. Basit, as a result, is a totally ruined. Anil is liable to pay Basit only the principal sum and interest on it. I guess it is a very much simple. It means that if a person is going to suffer from any kind of loss or damages, then it need to be paid. Otherwise, if no one is going to be suffer from any kind of damages, it is not be a part of the uh, it is not part to be of this compensated manner. But regardless, the market price fluctuation of the market price cannot be overruled this type of all thing. Number two is special damages. Section 73, it says that the damages include the indirect loss on also which may arise due to breach of contract. The parties must be aware of the loss which may be arise from the breach of the contract. It is important to note that the notice or to this effect must have been given to other party. If he had no knowledge of such circumstances, he is not responsible for damages. Subsequently, knowledge of the special circumstances will not create a special liability or a guilty party laid down in section 73. In easy word, I must say both parties should be well aware of that type of all things. If any person is not be aware of this type of damages, then another person, it means a aggrieved party is not liable to pay the damages. Let's take the example of this special damages. Atik delivered sample of NWR company for exhibition at a Newcastle. He wrote and consignment must be at a Newcastle on Monday. Certain due to negligence, the goods reached after the show. The company was aware that the object of the carrying the goods there held a thief could call special damages. Simpson versus Land and NW Railway, 1878 1 QB 274. Whatsoever is mentioned in this bracket, it means it is a reported cases which is uh, already this type of cases deal with the honorable high court or any kind of competent court. The simple is let's take another example to understand this special damages. Being an organizer, I organize some stall at Karachi Expo Center, and I already informed that my supplier, if you unable to deliver me my product which I am going to sell at that place, then I cannot take orders from my customers. Due to this, I am suffer from irreparable losses. So it means both parties, even the supplier and myself, are well aware that product need to be delivered on rightly time so that he able to get the orders from their customers. In case no delivery on the right time, then obviously I'm suffer from the losses because I need to be pay the amount of the exhibition and a stall amount which I need to be compensated from my earning sources. If there is no order, the whatsoever amounted I pay for the stall, I have to be bear from my own pocket. In that case, the guilty party can compensate me. If there is no information to that party, there is no compensation. Let's move to like damages number three. That's called the exemplary damages. Exemplary damages, the breach of a contract result in a monetary loss to the aggrieved party and cause disappointment. Exemplary damages have no place in law to contract, are not recoverable. These are awarded in the following cases. Number one, in case of a breach of a contract to marry, the amount of damages will depend upon the extent of injury to the feelings of the party. Number two, in case of the dishonor of a check by a banker when there is a sufficient funds, the credit to funds to the credit of the customer. The rule is the smaller the check dishonor, the greater the damage. Okay, there are two things in exemplary damages. Uh, in case there is a monetary loss involved in this manner, so the exemplary damages have a no place in law of contract, are not recoverable. But there are some cases. Let's take one case. Number one is a breach of contract of marriage. It means if a person can be a contract to marry with some male or a female, and the amount of damage will depend upon the extent of the injury. And if someone disowe the king that I am not going to be a part of this thing, so here there is a no physical damages or financial monetary loss over there except the feelings of the parties. In situation number two, if a bank is going to return my check, and at that time I do have a sufficient balance. Let's take an example. I have a balance of rupees 100,000 and I issue a check of rupees 50,000. Apart from rupees sufficient balance, 50,000 balance is available in my bank account. But but bank of is going to dishonor my check. So the word, the greater the damage, sorry, the rule is the smaller the check of dishonor, the greater of the damage, the greater of the damage. Okay, let's take the example. OS Bank promised to give loan to Mr. Wasim for a trip of LA by crediting his amount. He failed to do so. As a result, Wasim's check were dishonored. The court allowed damages for the mental suffering. Western versus Olet State Bank. Let's move to another damages. It's called the liquidated damages. Liquidated damages pertains to the contract fix the amount of the damages for the breach of contract. The liquidated damage, the at the breach of the contract at the time of frame formation of the contract. Such damages are called the liquidated damages. Liquidated damages represent only a fair and a responsible estimated of loss which a part may suffer due to breach of the contract, where a sum is agreed is to be contract to be paid by that defaulting party. In case of a breach of the contract will allow the reasonable damages not exceeding the amount already agreed. Please note, I'm going to read one more time. In case of a breach of a contract, the court will allow the reasonable damages not exceeding the amount already agreed. If the actual loss is more than the agreed amount, the damage will be paid to the agreed amount laid down in section 74. Let's take the example to understand the liquidated damages. Asif contracts to pay rupees 20,000 as a damage to Basit if he fails to pay him rupees 5 lakh rupees on a given day. Asif fails to pay on that day, Basit can recommend damages not exceeding rupees 20,000. This kind of damages is predefined. It means whenever we are going to be in fear or in harm that that person is not reliable, or it is a reliable, in case of any mishap the amount is already fixed in at the beginning of the contract. So it means no one is going to be cross the limit or beyond the amount which is already predefined. So it is one of the best damages which I like it rest of the all damages. Let's move the last nominal damages. These are neither awarded to the compensate aggrieved party nor the punishable to the guilty party. When the aggrieved party suffer no loss, the court may award him nominal damages in a recognition of this right, but the court has a discretion in this case. The court may refuse to award damages. So this is very simple kind of damages. Let's take the example and try to understand what the nominal damages says. Asif promises to sell cement to Ashraf for rupees 200 rupees per bag. Asif does not supply. At the time of breach, the market rate of cement is the same. The Ashraf is entitled to nominal damages. It means a person who is going to supply any sort of ingredient or any kind of grocery at the same rate, but at the time of delivery he does not deliver the product on the same time. However, he delivered the product after a week or after the day which is not a part of the contract, but at that time the price remain the same. There is a no change in the fluctuation in the price. So in that case there is a no specific damage. However, he is entitled to a special nominal damages so that he can be more careful in future time. Number three is a suit upon quantum merit. Uh, we have another type of suit. Okay, we already read the five type of damages, which is again I'm going to read one more time. That is the damages are called the ordinary damages and the special damages, exemplary damages, liquidated damages, and the nominal damages. Now in actual remedies we have a third type of remedy that's called the suit upon the quantum merit. The term quantum merit means payment in proportion to the work done on reasonable value of work done, where a person has done some work under a contract and other party cancels the contract or an event happens which make the performance of the contract impossible. Such party can claim a remuneration of the work already done. The right to claim for quantum merit arises when the original contract is discouraged. If the original contract exists, the party not is default may sue for quantum merit. The aggrieved party may sue in the following cases. Number A, when an agreement becomes subsequent void, when there is a promise to render services but not agreed about remuneration, when something is done without any intention to do so gratuitously. Next is when the contract is divisible, when the completion of the contract has been prevented by the other. Let's take the example of this quantum merit is Bina contracts to build a three-story house for Ashok. When one story is constructed, Ashok prevents Bina from working more. Bina can get the compensation for work done. As simple as if you remember, I already mentioned you an example of when I'm going to taught you performance of a contract in a jointly basis. If a person is going to intend to be work done but someone is going to refrain or stop them for working, so in the same manner, if I being a contractor, I made a contract with the owner of the house that I'm going to made a three-story or a five-story house for you on a certain amount. When I completed the first floor, he restrained me not to make for construct further floors. So being my responsibility, I need to be pay the amount which the work he or she already done. Number four type of remedy is a suit for a specific performance. A specific performance means the actual carrying out of the contract by a party. In some cases where the damages are not an adequate remedy, the court may direct the guilty party to fulfill the contract. The aggrieved party can sue for specific performance. It is granted in the following cases. It means that if there is any kind of thing where need to be performed, it means that the performance of the contract cannot be impossible, that it's impossible. So in that case, court is going to order the aggrieved party to perform the contract, and specifically, so there are three cases there we need to be make notice. Number one case is where compensation money is not an adequate remedy. Number two, where it is difficult to calculate the actual damages, where the compensation in money cannot be obtained. A specific performance is not granted in the following cases. Now there are three cases. There are three cases where a specific performance cannot be granted. Where damages are not adequate remedy, where the court cannot supervise the actual execution of the contract, for example, a building construction contract, where the contract involves a person, skills, taste and qualification, etc. contract to marry. There are three cases. If you remember, I already mentioned you in my previous slide that about the personal type of nature, like skill based thing, where the court cannot make a specific order the specific performance to complete this point number three. The court cannot granted this type of all thing. Moreover, in point number 2 and 1, it is a this is these three are the situation, but you can try to be understand from the point number 3. Okay, there are cases where the aggrieved person needs to be fulfill the amount. Let's take if I am going to supply the some food products and it's a perishable goods. Here I do not know how much my food is going to suffer in this all type of thing, and that actual damages is very much difficult to calculate the things. So in that case, this will be work out. Let's take the example to make it all clear and easy manner. Aisha agrees to sell her plot of land to Kamran, who agrees to purchase it for erecting him mill there. Due to certain inconveniences, Aisha committed breach at the suit of Kamran. Aisha is asked by the court to carry out the contract. For example, if I buy a land intention to build or construct a any kind of flats in a commercial area. However, I borrow some kind of money from the investors. So in that case, court cannot stop me to disassociate from this contract. He may allow me because there is a another interest of other people are going to be intact with this kind of thing. Number last is suit for injunction. Suit for injunction, basically it is a kind of where we are going to restrain some person to involve in that matter. For example, any person is going to grab the person's property. Let's take this example in very simple manner. I'm going to I do have a plot of piece of land. Someone is going to enter in my premises and show himself that his property belongs to me. Under that circumstances, I seek the remedy from the court and also take kind of plea that I need a kind of injunction and restrain some person to enter in my premises until the decision of the court when the case is going to be finalized. So these are the remedies which I already told you. Let's take a quick review what I mentioned you in this slides. Number one, as I already told you, it is a remedies. Whosoever is not going to perform the contract, we have a remedy, legally remedies to be enforce that person to be part of the contract, whether it is a kind of damages or a injunction. So there are five type of cases where we can take our remedy. Number one is suit for recession. Damages are of five types. These are the five types of the number. Next is suit for quantum, suit and suit for specific performance, and the last is suit for injunction. Thank you so much class to be a part of this lecture. Inshallah we are going to meet with the next lecture and next slide.